Moving on to our keynote address for you this morning, Internet, New Technologies and the Law, presented by Judge David Harvey. Many of you know, and he's been contributing fully and mentioned in many, many tweets that we've had over the last couple of days. Just to give you the bio for him, of course, Judge David Harvey was appointed a District Court Judge in 1989. He's been closely involved with information technology initiatives involving the judiciary undertaken by the former Department of Justice and the present Department of Courts, including the development of trial management software. In addition to his judicial duties, Judge Harvey is consultant editor for Butterworth's Electronic Business and Technology Law and a member of the editorial board for Butterworth's Technology Law Forum. He is a part-time lecturer at the Faculty of Law, Auckland University, teaching law and information technology. He's written extensively in the field of law and technology and has presented a number of papers to conferences both in New Zealand and overseas on related topics. He was chair of the Copyright Tribunal for 6 years and has published a book on the law and network systems entitled The Internet Law.nz, Selected Issues, now in its third edition. That's what the official bio says, but also I can tell you he's very recently been awarded a PhD by Auckland University, which is an absolutely fantastic recognition for the work that he's done. As a practicing lawyer, I can tell you that his judgments that involve, particularly those involving technology and the law, are very, very widely read throughout the international common law world. So he's very, very influential in that field. And the little bit of trivia that some of you know and some of you may not, of course, he is a mastermind. He was New Zealand's mastermind way back when, and a specialist on Tolkien. So we're very, very privileged to have him as our, back before it was really cool. We're very privileged to have him as our keynote speaker this morning. Please welcome Judge David Harvey.
Thank you for that, Jim. I'd forgotten the last bit. What I want to do this morning, just briefly, is to cover off on a few things that we've been talking about over the last couple of days. And it's within this umbrella of Internet and New Technologies and the Law. And I've subtitled it An Uncomfortable Fit, because there are areas where it may be uncomfortable when we're looking at a time of disruptive change. So we'll get started now, as soon as this thing goes. No? Yep, here it goes.
I know you're up. I can feel you now. I know that you're afraid. You're afraid of us. You're afraid of change. I don't know the future. I didn't come here to tell you how this is going to end. I came here to tell you how it's going to begin. I'm going to hang up this phone, and then I'm going to show these people what you don't want them to see. I'm going to show them a world without you. A world without rules and controls, without borders or boundaries. A world where anything is possible. Where we go from there is a choice I leave to you.
Neo's themes, if you like, in his last message in the first of the Matrix trilogy, deals with issues of change, with the fear of change, with the choices that we have, and the existence of rules in a world without borders. And I thought it made a nice little introduction, a nice little summary to some of the themes that I want to cover off on now. Let's go back to 1992 and imagine Rip Van Winkle has gone to sleep and look at the information technology world that he is living in. There's limited internet availability. It's all dial-up, remember that? There are bulletin boards, there are Usenet groups, there's email, and the World Wide Web has only just begun. So Rip wakes up 20 years later, and what's happened? There has been dynamic, dramatic change. We've now got high-speed broadband, we've got cheap, available internet, we've got computer systems that Rip Van Winkle wouldn't have imagined in 1992. Laptops, notebooks, airbooks, all sorts of stuff. Wireless as well. Windows, which was an operating system in its infancy in 1992, has gone through all sorts of iterations. We've had business models that have died, Napster, Grokster, Kazaa, for example. And we've got new business models that have come on stream, like Google. We've got social networking coming in. We've got Facebook, we've got Twitter, we've got streaming video, we've got media convergence. What's a newspaper? Well, if you go online, it can be anything that you imagine. We've had the dot-com boom and bust. We've had a couple of those. We've got digital cameras, iTunes, mobile devices. No aspect of our lives today is untouched by modern communications technologies. You cannot avoid it. And of course, waking up and confronting this dramatic change is probably wishing that it was the way that it was 20 years ago, because the change has been too much, it's been too fast. And in many respects, and as Vikram suggested, he's not alone. Today, we are at a crossroads. We can destroy the advantages that the internet gives us. We can destroy the advantages of change, or we can make some smart choices and we can head on into our new digital future. There are two roads that we can travel, because what is going to happen is the choices that we make now are going to govern the lives of our children and our grandchildren, who will be the digital natives. I am not a digital native. I am a digital immigrant. I don't speak with the accent of the digital native. But the one path that we can follow doesn't do much for creativity, doesn't do much for innovation, doesn't do much for self-expression. It's going to lock it all down. It's going to clamp it all up. The other path looks at the advantages that we can take from new technologies, recognizing the risks, dealing with the risks, but not at the expense of the new technology. And here's the thing. Problem is that the first option is probably going to happen more likely than the second, and the reason for that is fear. Because we're afraid. As Neo said, we're afraid. And I call it the Frankenstein complex. Mary W. Shelley, back at the beginning of the 18th century, writes Prometheus Unbound. The doctor creates a being, creates a model of man. And it gets out of control. And it's been a common theme in literature, particularly science fiction, ever since. HAL 9000 in 2001, A Space Odyssey. The computer run rampant. It had a hidden agenda. And of course, the very successful Terminator franchise is built upon the premise that the technology is going to run rampant. The technology is going to be out of control. Part of the problem is that that type of fear, that type of worry is taken up, as Simon Power said in October of 2010, describing the online world as a wild west. It's taken up, and there needs to be some kind of rule, there needs to be some kind of regulation, there needs to be some kind of standards. And of course, media feed the fear with their stories of cyberbullying and online sexual predators, internet addiction. There was an interesting story on television just the other day about addiction to smartphones. I was wondering whether or not, in fact, it was a failure to recognize that this is the new way that people are going to communicate. There's pornography, there's data leaks, WikiLeaks, and so on and so forth, and none of this is new. We've had bullying for centuries. Sexual predators used to sit outside schools in their cars with a bag of candy. Addictions have been around for as long as man has been. You just need to go to Pompeii and to the archaeological ruins to see some pretty interesting pornography. And some of you may remember Daniel Ellsberg and the Pentagon Papers. That was a story of a leak as well. It's not the technology. It's a matter of behaviour, because all of these behaviours predate the internet. It is not the technology. We, in fact, are the problem. As I've said earlier on at this conference, and there's the source, we have met the enemy, and he is us. It's our problem. It's behaviour. And the thing is that this fear that we have of new technologies may lead to a reaction, and often this reaction involves the law, as Simon Power suggested. Let's take a few examples. These are cases that dealt with copyright issues. And I focus upon them because they are interesting ways in which the courts were called upon to address new technologies. First was the Betamax case. Betamax was a video cassette format. There was a contest between VCR and Betamax, but it's called the Betamax case because it dealt with Betamax. What had happened was that Sony had developed the Betamax video recorder. The Motion Picture Association got very upset about this. In fact, Jack Valenti, who was the chair of the Motion Picture Association of America, said that the video cassette recorder was to the movie industry as the Boston Strangler was to women living alone. The matter went all the way to the United States Supreme Court. The movie industry wanted the Betamax video recorder banned because it was involved in copyright infringement, the recording of television programs and movies. The United States Supreme Court said, no, we're not going to ban it because this device has a whole lot of substantial non-infringing uses. You can record a program and you can watch it later. That's called time shifting, and that's okay. And what happened was that it did not uphold the movie industry's request to have the video cassette recorder banned. So what happened was that the movie industry recognised that at last they had a business opportunity here. They could release all of their back catalogue on videos. And they could release on video cassettes, and after video cassettes they could release them on DVD. Hollywood makes more money out of DVD sales than it does out of the box office. Just imagine if that business opportunity had been lost as a result of the banning of the video cassette recorder. Similarly with the Diamond Rio. The Rio was an MP3 player, one of the early ones. The recording industry wanted to ban people format shifting their CDs into MP3 format and listening to them on their Rio MP3 player. The court similarly held no, because format shifting is okay as long as you've legitimately acquired the CD. That's all right, not a problem. Just imagine what would have happened then if MP3s had been banned. No iTunes, no iPod. A loss of a business opportunity. The reel-to-reel cassette recorder, this was an English case, CBS Songs and Amstrad. Obviously, it's being used for copyright infringement, said CBS Songs. No, said the court, there are a whole lot of non-infringing uses to which it can be put. It's not been marketed as a device for infringing copyright. We're going to let the reel-to-reel cassette recorder remain. So you can see that sometimes the law can be rather a clumsy object when it comes into contact with technology, and fortunately in those cases, the requests by the various copyright owners were not upheld and new business opportunities developed. And you sometimes wonder when new technologies come online why it is that people try to shut it down rather than take advantage of the new opportunities that are presented. Cases are one way, legislation is another. And the legislative process, as far as I'm concerned, has an awful lot to recommend it. In this country, there are a number of pieces of legislation that deal with new technologies. The first was an attempt in 1994, the Technology and Crimes Reform Bill. If that had ever got passed, the internet wouldn't be with us, because the costs of compliance that were required in those days meant that ISPs were saying, we can't live with this, we're going to go out of business. It wasn't passed. But there have been subsequently a number of other pieces of legislation. The Electronic Transactions Act is a big umbrella piece of legislation that validates electronic transactions in the same way as paper. It's a lovely piece of legislation, and I say that not because, lawyers have this affair with legislation, but because there have never been any cases on it. It is a piece of statute, it is a piece of legislation that has worked and worked admirably. And the consultation process that went on